tempos de cobrança de atitudes éticas por parte das empresas, governos e partidos políticos, cresce a preocupação em alguns setores do empresariado com o combate a fraudes e desvios financeiros. Nos Estados Unidos, a obediência à legislação e a busca pelo cumprimento de normas rigorosas de conduta pelas corporações ganhou o nome de compliance. E esse é o campo de trabalho do convidado de hoje do Roda Viva, o ex-presidente da SEC, a Comissão de Valores Mobiliários dos Estados Unidos, Harvey Pitt.
Boa noite. Estamos no ar em todo o país pela TV Cultura, pelas emissoras afiliadas e pelo nosso canal no YouTube. Hoje, a nossa bancada de entrevistadores é formada por Fernando Torres, repórter do jornal Valor Econômico, Márcio Croen, editor da revista Isto é Dinheiro, Laura Diniz, editora do site JOTA.INFO, HELEN BRAUN, apresentadora da rádio Jovem Pan, e Rafael Valim, advogado e professor de Direito Administrativo da PUC de São Paulo. Contamos também, como sempre, com os desenhos feitos em tempo real pelo nosso cartunista Paulo Caruso. Agora você pode acompanhar as edições do Roda Viva em seu celular e também rever entrevistas anteriores. É só baixar o programa na loja de aplicativos do seu aparelho. Mr. Pitt, em primeiro lugar, muito obrigado pela aceitação do convite para participar do programa. Seja bem-vindo ao Roda Viva e ao Brasil. Eu começo perguntando quais são as ilegalidades ou irregularidades praticadas com mais frequência pelas empresas.
First, let me thank you for the invitation. It's a pleasure to be here with everyone.
Thank you.
The types of corporate misconduct we have seen in the U.S. Is varied. There are a great many financial frauds. There are corruption, acts of corruption. There are acts of market manipulation and insider trading. All of them adversely harm citizens and innocent investors and shareholders and threaten the economic well-being of any country in which those acts occur.
Laura Diniz, abre a roda.
Mr. Pitt, boa noite. Quando uma empresa estrangeira vem comprar uma empresa no Brasil, essa compra normalmente é precedida de uma due diligence, ou seja, de um pente fino em todo o funcionamento da empresa que vai ser comprada para que essa compra seja negociada. Com base nas due diligences de empresas brasileiras que o senhor, com que o senhor já teve contato, qual é a imagem que se tem nos Estados Unidos das empresas brasileiras?
Due diligence is absolutely critical before an acquisition can be made. The truth, however, is that if there has been wrongdoing at, say, for example, a Brazilian company that is a U.S. company wishes to acquire, if that wrongdoing was deliberate, it may be virtually impossible for due diligence to uncover the fraud. The more intentional and deliberate the fraud, the harder it may be to figure out exactly what occurred. That is why, in addition to due diligence, there are representations and conditions prior to a closing in which the acquired company makes representations about the accuracy and validity of its statements. So those can be exceedingly valuable if it later turns out that due diligence did not find a particular problem at the acquired company.
Então, só complemento. De forma geral, qual é a imagem que as empresas americanas têm das empresas brasileiras?
I think that it would depend first on the time at which you ask the question. It may not be quite as high today as it was, say, 2 weeks ago or 3 months ago. But I think in general, American businesses hold Brazilian companies in high esteem. They believe that Brazilians function under a carefully constructed rule of law, and they have a great deal of confidence in the integrity and morality of Brazilian citizens. Needless to say, in individual cases, that may vary depending on reputational and other issues, but I believe that Americans hold Brazilian companies in high esteem.
Fernando Torres.
Mr. Pitt, a lei anticorrupção brasileira ela foi inspirada em legislações semelhantes dos Estados Unidos e de outros países da Europa. E tanto nas punições como também na existência de acordos de leniência para que se encerre todo o processo sem que seja necessário um julgamento ou uma punição. Se faz um acordo, a empresa normalmente paga um valor financeiro para o regulador e se encerra o caso. Mas há uma particularidade no mercado brasileiro, que é a existência de muitas companhias com um acionista controlador. E existe uma percepção de que os acordos de leniência tradicionais, em que a empresa paga um valor financeiro e, eventualmente, diretores ou executivos específicos são afastados, isso não seria suficiente para educar ou inibir acionistas controladores de adotar essa conduta no futuro nas próprias empresas ou outros controladores de outras companhias não seriam educados por um acordo desse tipo. O senhor entende que é razoável, num acordo de leniência, numa sociedade como a brasileira, envolva também uma punição para os acionistas controladores, seja na forma de, por exemplo, devolução de dividendos, ou mesmo de obrigando eles a abrir mão do controle da companhia ou das ações que eles têm na companhia?
There are a number of aspects to your question, and let me start first by saying, although I know it is the phrase used in Brazil, I do not like the term leniency agreements. In the US, we call them corporate responsibility agreements, and the point is not to provide leniency, but to provide accountability and provide responsibility for misconduct. There have been situations where US or other countries' companies have been controlled by a large shareholder, by a family, what have you. Those present very difficult circumstances. First, the issue becomes what wrongdoing took place and who was responsible for the wrongdoing. If the responsible parties acted in violation of corporate policy, or beyond the knowledge, say, of a controlling shareholder, then although there is a need for better responsibility, it would not necessarily follow that the controlling shareholder should be ousted from any control or any ability to receive dividends. If, on the other hand, the controlling shareholder participated in the wrongful conduct or facilitated it or turned a blind eye to it, then there is a need to establish a structure that would make the regulators and the public less dependent on how the controlling shareholder reforms its behavior. There is often brought in corporate ombudsman, for example, someone who does not owe his or her job to the controlling shareholder and who cannot be fired by the controlling shareholder to report both to the board of directors and to regulators if anything untoward is taking place at the company. In some cases, if the wrongful conduct was the deliberate product of a controlling shareholder, then there may be required far more dramatic and drastic changes. So it will depend on both the factual circumstances and what protections and safeguards can be put in place to avoid a recurrence of the same improper conduct.
E também de reparação, quer dizer, poderia voltar para o passado também. Se de fato o acionista controlador atuou diretamente nos casos ilegais.
If controlling shareholders were directly involved in the violation, in the U.S. there will often be a personal economic sanction imposed on those people so that they cannot benefit from the wrongful conduct that took place. And so people can go back. In 2010, the U.S. passed legislation which permits something called a clawback. And that is if a controlling shareholder, CEO, has presided over improper conduct and is found to have responsibility for that conduct, their salary can be clawed back, their bonuses can be clawed back, and they can, in fact, under the U.S. law, be prevented from being an officer or a director, not just of that company, but of any public company.
HELEN, BRAUN.
O senhor foi uma das pessoas que participou e levantou as investigações envolvendo a companhia Enron nos Estados Unidos. E no lado político dessa história, uma das coisas que todo mundo tentava entender é em que medida essa empresa acabava influenciando a política energética da administração norte-americana. Aqui no Brasil, o governo atual usa um pouco a Petrobras como uma espécie de cheque especial, assim, quer dizer, controlou o preço da gasolina, quando estava o petróleo alto no mundo todo, aqui o preço da gasolina era baixo, agora que o petróleo está caindo, o preço da gasolina aqui é alto. Em que medida as ações que a Petrobras tem perdido na justiça norte-americana se dão mais por um desconforto com a influência do governo brasileiro sobre o combustível e as políticas energéticas aqui, ou são medidas estritamente relacionadas à corrupção? Porque as ações até hoje lá, o que se alegou é que a Petrobras não tinha aí informado o seu grau de corrupção, descumprindo algumas normas do organismo de controle norte-americano. Então, o que está pesando mais nesse momento para a Petrobras perder tantas ações na justiça norte-americana diante desse cenário de crise?
Part of the litigation against Petrobras in the U.S. is a function of the fact that there are U.S. citizens who bought shares of Petrobras and who are now arguing that it should have disclosed some of the events that are now making headlines in Brazil, but did not disclose that before they purchased their shares. In my view, the difficulties at Petrobras are Brazilian problems, and I believe very strongly they should be solved in Brazil, not in the U.S., and that U.S. courts are ill-equipped to resolve some of these issues because the facts are still evolving and the issues are still being developed. So people complain about a loss in the value of their investment. And of course, that's a concern. But unless Petrobras disclosed something about that at the time, they will always have a concern. My view, however, is the real issues are Brazilian. For one thing, did corruption take place? It appears from the news reports that there was corruption. If there was corruption, there are two sides to corruption. There are those who try to bribe officials, and then there are officials who accept the bribes. If the corporate officials who are offered money do not take it, you cannot have corruption. The people who offer it still violate the law because they attempted corruption, but there is no completed act of corruption. So when directors and others at a company like Petrobras, which is both governmental and private in that it sells its securities, take bribes, if they did, then it seems to me these issues have to be resolved here in Brazil and not in U.S. courts under the U.S. securities laws. That is the wrong way, in my view, to get to the bottom of this and to correct the injustices that have taken place.
Márcio.
Mr. Pitt, eu gostaria que o senhor falasse sobre conselho, a importância dos conselhos nas empresas. No Brasil tem algumas confusões, como presidente executivo é o mesmo presidente do conselho, tem algumas pessoas que fazem parte de mais de um conselho, e esse conselho não parece apto a analisar o que acontece na empresa e evitar que aconteçam casos errados. Qual a importância real do conselho? O que esse conselho também pode ser responsabilizado em casos de corrupção, de quebra de empresa, de estratégias erradas, enfim?
The first place to look within any corporation is the fiduciary board, the board of directors that has the ability to take action on behalf of the company. fiduciary duties are very serious, they're very strong, as they must be, and directors cannot turn a blind eye to potential corruption or misconduct. Advisory boards tend to serve a different function. First, they are not fiduciary boards. They do not have decision-making power. All they can do is render advice to try and help the corporation and its actual directors, its fiduciary directors, to achieve the right results and the right answers to specific problems. On the other hand, advisory boards are often made up of people of stature, people who are believed to have high integrity. They must live up to that, and they must do their job by directly confronting difficulties and giving sound advice. But they are not liable for misconduct on the part of a corporation. Those are the actual directors. But if an advisory board becomes aware of misconduct, it can use the stature of its members to help the company come up with an appropriate response to the difficulties and minimize the amount of damage that may occur. And that is something they definitely should attempt to do.
Bem, nós temos 3 minutos para a última pergunta e última resposta do bloco. Rafael Valim.
Vamos lá, Mr. Pitt. O Brasil vive atualmente uma euforia no tocante ao combate à corrupção. O que, entretanto, segundo me parece, custará caro ao país. Tá? De um lado, temos assistido, também na minha opinião, diversas violações à Constituição Federal de direitos fundamentais. E, de outro lado, há uma desconsideração, né, da função social da empresa, da importância das empresas nacionais para o desenvolvimento do país. Né? Como conciliar combate à corrupção e a preservação da atividade econômica?
Your question focuses very importantly on the need for a balance and for correctly assessing what the appropriate responses are to particular problems. In the U.S., we have a saying, don't throw the baby out with the bath water. If the bath water is dirty, you replace it. You put in clean water. But you do not throw out the baby, because doing so would be terribly destructive. With corporations, the balancing and need for proportionality has to look at the fact that, first, a successful company provides goods or services that citizens enjoy, like, and wish to continue to enjoy. It employs thousands, perhaps tens of thousands or hundreds of thousands of citizens who thereby can earn a living and contribute to the local economy. And by paying taxes as well as hiring people, it can elevate the local economy of the country in which it is doing business. Those are all very important benefits that should not be overlooked when trying to define how a corporation should respond if it has been involved in misconduct. Even the best of companies occasionally stumble. And in order to help them, they need to develop a corporate responsibility agreement, an approach that allows them to continue doing all the good things that the company can do, but provides meaningful assurance that the bad things that may have occurred are not likely to ever occur again. The people need assurances of that, but simply attacking these companies and using draconian remedies would in effect be throwing out the baby with the bathwater.
Vamos para rápido intervalo e voltamos já já com o consultor Harvey Pitt, especialista em leis concebidas para impedir a ocorrência de fraudes financeiras. Vamos de volta para o segundo bloco da entrevista com o consultor Harvey Pitt. Mr. Pitt, o senhor disse que os problemas dos acionistas americanos prejudicados pelo que houve na Petrobras devem ser resolvidos pelas autoridades brasileiras. E se não forem, eles têm como recorrer a tribunais americanos?
If companies raise money from U.S. investors, they are required to be honest and truthful with those investors, and if they are not, they have a valid cause of action under the U.S. securities laws. If there is no resolution in Brazil of some of these issues, then there may be no alternative but to pursue those rights in U.S. courts.
Helen, vocês inverteram?
Pediu uma licença ali.
Então, Fernando, depois a Helen.
Porque tem um tema em linha com o que você perguntou, Augusto. Eu queria entender melhor essa questão da jurisdição, né? Se esse caso deve ser resolvido de fato aqui no Brasil ou não. Até onde eu entendo, tem dois processos ou potenciais processos contra a Petrobras nos Estados Unidos. Um ligado a uma alegada violação à lei de mercado de capitais, ao Securities Act, e que é a class action, que é a ação de classe movida pelos investidores. E um outro processo ligado à possível violação da lei anticorrupção dos Estados Unidos. O senhor entende que nenhum desses casos está sob a jurisdição dos Estados Unidos, ou um dos casos sim e o outro não?
U.S. shareholders who are injured by alleged misconduct by a Brazilian company have the right to sue in U.S. courts, and those actions are less of concern, I would say, although even there my concern is the facts are still not fully developed. And so a U.S. judge in the United States is very ill-equipped to make decisions when the facts haven't been evolved. With respect to foreign corruption, the U.S. law really protects against companies that pay, U.S. companies that pay foreign bribes to obtain or retain business. In the case of the corruption allegations with respect to Petrobras, that would seem to me not to be relevant because Petrobras is a Brazilian company and it didn't essentially pay bribes. If the claim is that it should not have accepted bribes, that strikes me as being peculiarly within Brazil's competence to handle and very much not in the competence of the U.S. court or judge.
Sou uma empresa que facilita.
Fernando, eu preciso girar a roda. HELEN Brown.
No último bloco você me respondeu e falou sobre a corrupção que tem os dois lados, né? Grandes companhias, mesmo que não prestem diretamente serviço para um governo, elas têm interligações no governo. A própria Enron, quando foi investigada, tinha aí contratos na casa de 70 bilhões de dólares com o governo norte-americano, tinha contratado, pelo menos uma pesquisa, uma reportagem da Times, que havia contratado assessoria de imprensa para a campanha do ex-presidente George Bush. Tem como, pelas investigações que o senhor já fez de grandes companhias, uma empresa fazer tanto cambalacho, para a gente usar um bom português, sem que haja pelo menos um consentimento ou uma omissão por parte do governo?
I'm not sure I fully understand your question, and rather than try to give you an answer, perhaps you could clarify that for me?
Em que medida os governos são coniventes com as corrupções dentro de grandes empresas?
If companies are aware of corruption, they should not take a blind eye to it, and they should not simply allow it to go on. But there are avenues for raising these issues. There are, in a country that follows the rule of law, there are regulators, there are prosecutors, there are legislators who can address issues of corruption, assuming they are not also involved, which sometimes, unfortunately, occurs. But sitting idly by while misconduct occurs demonstrates a lack of integrity and is something that should not go on because eventually the companies that witness this but don't participate in it will themselves be adversely harmed by the fact that other companies engaged in this misconduct.
Laura e depois Rafael.
Mr. Pitt, o senhor foi presidente da SEC, que é a equivalente à Comissão de Valores Mobiliários aqui do Brasil, um órgão que, em determinados casos, pode impor multas a empresas envolvidas em escândalos, em esquemas de corrupção. Especula-se já aqui no Brasil que deve ser grande a multa que a SEC vai impor à Petrobras por conta desse escândalo todo. Especula-se. A minha pergunta é a seguinte: como a SEC costuma punir empresas estatais que se envolvem em corrupção? Eu faço essa pergunta porque os acionistas dessas empresas já foram punidos com a desvalorização das empresas, com essa conduta criminosa dos controladores, e ainda a empresa tem que arcar com uma multa, muitas vezes imposta pelos órgãos reguladores. Como é que isso funciona lá?
I think first it's important to understand that there are no direct analogs to state-owned companies the way there are in Brazil. In the U.S., we have had what is known as GSEs, government-sponsored enterprises, like Fannie Mae and Freddie Mac. And those companies are private, but they are backstopped by government guarantees. They are what is the closest analog to what you are discussing. And in the US, we have had the SEC take serious action against Fannie and Freddie. First, when I was chairman, both of those companies claimed that their disclosure was as good as normal public companies' disclosure. My response was, if you believe that, put your money where your mouth is and agree irrevocably to be governed by our disclosure laws, which Fannie Mae did. Freddie Mac agreed to do it, but after I left, they never wound up fulfilling that agreement. When it was clear that misconduct had occurred, in the case of Fannie and Freddie, it was financial fraud, and there were questions about spending on lobbyists for government to get preferential treatment. The SEC took action. The individuals who were running the company lost their jobs. Eventually, private suits were brought and were settled for hundreds of millions of dollars. Then Fannie and Freddie were put under a government conservatorship. So there is some parallel, and when we see wrongful conduct on the part of these kinds of corporations, the individuals who are responsible are severely dealt with, and the companies are then required to restate their financials and start to comply with their legal obligations.
E o senhor
Rafael,
já viu, só uma emendinha.
Isso, rapidamente, porque senão não consigo completar.
O senhor já viu a SEC punir alguma estatal de outro país?
It can, depending on what the state-owned company has done, and to U.S. investors. When I was chairman, when that issue came up, we consulted with our State Department because I was reluctant to have the SEC take action without considering the diplomatic reactions that might occur from that.
Rafael Valim.
Vamos lá. Uma das respostas estatais, né, possíveis diante de atos de corrupção são essas que chamamos as sanções restritivas ao direito de licitar e contratar com o poder público, ou seja, proíbe-se que as empresas infratoras sigam contratando com o poder público. Ao mesmo tempo, porém, em diversas partes do mundo e agora também no Brasil, há o que chamamos do Instituto do Self-Cleaning, ou seja, a possibilidade de autossaneamento das empresas, né? O senhor poderia nos explicar como isso funciona, né, no sistema norte-americano?
Yes, one of the important concepts, and when I was SEC chairman, I wrote a release directly on this subject announcing the SEC's policy. If companies find wrongdoing on their own and they take important corrective action themselves and then report what they have done to the government, I believed that depending on the circumstances, those companies should receive credit from the government and not be adversely affected by doing the right thing. In some cases, if the government finds the problem first, companies often will sit back and wait to discover whether anybody thinks they've done something wrong. I believe that is the wrong approach. I believe that companies that are aware of the government investigation should do their own internal review, determine what the facts are, and then if they believe that improper conduct has occurred, correct it. In cases where the company doesn't want to decide whether the law is violated, they should still take action to prevent the same claims or allegations from ever arising again. And companies that do that should receive appropriate treatment from the government to encourage them for doing the right thing and to encourage other companies to follow that pattern.
Márcio Klein.
Voltando aos acordos de leniência ou de responsabilidade corporativa, as empresas no Brasil reclamam da segurança jurídica, porque no Brasil tem uma confusão que alguns acordos que você faz não são aceitos por outros órgãos e isso não é claro para que elas aceitem um acordo ou façam um acordo para mostrar tudo o que aconteceu de errado. Há alguma maneira de simplificar esses acordos, de torná-los mais fáceis, mais ágeis e menos burocráticos?
There are ways. It requires both sides to understand what the concerns are of each. In the case of the government, reaching a settlement too quickly may worry the government that they don't know everything. But there's a solution for that. In the case of companies, a long drawn-out, protracted investigation will tie the company up in knots. It will divert its management from trying to make the company better, and it will run up legal bills. The only people who gain from these situations, unfortunately, are the lawyers. And I can say that as a lapsed lawyer. But the important thing is for companies to acknowledge not that they have violated the law, but to acknowledge that they, as a matter of policy, don't want to engage in conduct that may have occurred, depending on what the facts are, to agree to have an independent review of that misconduct, and then to agree to abide by the recommendations that come out of that review. The government in the U.S. often reaches agreements that require exactly that kind of conduct, and I have served in that role for some companies as someone independent whose only responsibility is to help the company get better and to avoid repeating the same mistakes that the government thinks occurred. This can be done quickly because even if additional facts come out, the government will become aware of them and it can make certain that steps have been taken to prevent those from occurring again as well.
Fernando, como eu te interrompi quando você esboçava a pergunta, pode fazê-la agora.
Não, tudo bem. Eu vou aproveitar esse tema sobre colaboração das empresas com as investigações. A gente tem notícia de que uma empreiteira, uma das empresas investigadas aqui na Lava Jato, que é a Odebrecht, teria apagado os e-mails de ex-executivos da companhia com a alegação de que que eles se desligaram da companhia, deixaram de ser funcionários e que, seguindo uma política da empresa, todo o histórico de e-mails foi apagado. Esse tipo de conduta, com empresas já sob investigação, que tipo de consequência, sob a legislação americana, isso poderia ter de consequência negativa para a empresa numa situação dessas?
I, of course, don't know the specifics of what has or has not occurred. But speaking generally, not as to that situation, in the U.S., companies are required to produce records so that even if the individuals who may have engaged in misconduct have left the company, the records that they have remain behind at the company. And the company in the U.S. would be required to produce that documentation. It would not be the same as being able to interview executives who have left the company, but their records, their emails, and the like would be available. In the U.S., some prosecutors attempted to say that companies could not provide a defense for former officials, that is, provide lawyers or pay their expenses. And U.S. courts held that that was a violation of law, that if companies had provisions in their charters requiring them to pay the legal fees of former executives, the prosecutors could not require the company to cease paying those fees.
Vamos para mais breve intervalo e voltamos já já com o consultor Harvey Pitt. Voltamos para o terceiro bloco da entrevista com o consultor Harvey Pitt. Fernando, você não completou a...
Isso, eu só queria esclarecer um ponto para saber se, nesse caso de apagar e-mails ou outros registros de ex-funcionários, isso pode, de alguma forma, elevar a sanção a que a empresa investigada estaria sujeita?
It can, and that might constitute a separate violation, obstruction of justice. You are not allowed to destroy any evidence or information that may be relevant to matters that are under investigation. And one technique that is used at most corporations is to issue what is known as a document hold order, which is the company sends out an order to all of its employees saying no documents may be destroyed until further notice.
Perfect. Laura.
Mr. Pitt, o Departamento de Justiça americano, no ano passado, sinalizou um desejo de mudar um pouco o foco do combate a crimes de corrupção e de fraudes dentro das empresas, mudar o foco das empresas para as pessoas físicas. O senhor disse recentemente numa entrevista que acha que a prisão de executivos não traz benefício algum, exceto para o promotor que ganhou uma ação. Eu queria que o senhor comentasse um pouco a sua posição e esse anúncio do Departamento americano de mudar um pouco aí o foco da ação.
Yes, the announcement is known as the Yates Memorandum, and it isn't so much a switch of focus as it is a clarification that companies seeking credit for cooperation with the Justice Department must provide whatever evidence they have against individuals who may have engaged in misconduct. And unless and until they provide that information, they will get no credit for having otherwise cooperated with an investigation. The SEC has now long had a policy that if a company wishes to settle a matter, it can, but it must agree to provide whatever evidence is available so that the SEC can determine whether specific individuals may have engaged in misconduct as well.
HELEN BRAUN.
Aqui no Brasil, esse caso específico de corrupção envolvendo a Petrobras está conseguindo ter um desenrolar bom por causa, em grande medida, de delações premiadas, né? Só que isso não há um consenso sobre isso. Juridicamente se discute muito a validade dessas delações, o quanto elas são realmente eficazes, e agora até as grandes companhias, como a própria Odebrecht, aí aceitou que seus executivos fizessem delações caso eles entendessem que assim era melhor. Como que isso é usado nas investigações nos Estados Unidos? Vocês usam do artifício das delações? É uma coisa tranquila em relação ao Poder Judiciário norte-americano fazer delações e isso é encarado como um respeito também do direito do réu?
Yes, plea agreements are used in the U.S. Sometimes an individual who has first-hand knowledge will come into the government and in return for some agreement as to whether they will be sanctioned at all, put in prison or not, will reveal information. The way it works in the US, however, is it has a strange name. It is called Queen for a Day. And what it means is the lawyers for the individual will come in and say, if my client had a deal, he or she would tell you the following. And the government will explore that. Is there evidence to back it up? Is there a basis for us to believe the truth of this person, or are they just trying to get out of going to jail themselves or what have you? So there is a process for plea agreements. What there is not a process for, however, is what I guess is known as preventative detention, where people can be incarcerated without charges for some extended period of time. In the US, that is very hard, if not impossible, to achieve. At some point, if you want to keep somebody in jail, first there have to be formal charges, and second, there has to be a risk that they may flee the jurisdiction. Otherwise, they cannot be incarcerated without having been tried. But there is definitely a mechanism for people to make plea arrangements with the government.
Mr. Pitt, eu só queria lembrar que nós conversamos há poucos dias com o ex-ministro do Supremo Tribunal Federal, Carlos Veloso, e ele disse que a legislação brasileira sobre colaboração com a justiça, que é o nome correto, a imprensa que usa delação premiada, ela foi inspirada na legislação americana e é preciso que o depoente, o que faz as revelações, prove o que disse. Agora eu pergunto, o senhor acha possível desbaratar um esquema como o da máfia nos Estados Unidos ou como o do chamado petrolão no Brasil, sem que alguém envolvido com o esquema faça revelações?
I believe it is exceedingly hard to make cases without getting somebody who was a participant in the process. That's not to say that it's impossible, and it does happen. It is to say that the job of prosecutors is made so much easier if somebody can come forward and say, I was a part of this, I took part in it, here's what I did, and here is the objective proof that what I am saying is true. And the Queen for a Day process that I mentioned a moment ago carries with it also assurances to the government that there is some corroboration for what the individual is saying or will say if he gets a plea agreement. So I think the comments you heard previously were correct. I think this is a process in the U.S., but it follows a very orderly process that ensures ultimate fairness and that nobody can basically get a deal by simply suggesting that somebody else may have violated the law without there being some real objective evidence of that violation.
Temos 5 minutos para completar a roda.
O que a experiência com os casos Enron e WorldCom, que ficaram famosos no começo dos anos 2000, ajudou a evitar novas crises e aumentar a transparência no mercado? E como isso pode ser replicado em outros mercados também?
The difficulty with financial fraud is it is infinite. Fraud today may be very clever, and tomorrow people will come up with more creative ways to commit a fraud. So there's never an assurance that taking action today will prevent this from coming to pass tomorrow. In fact, it keeps happening, so we know, in fact, that it cannot provide a guarantee. But there is more transparency. The goal is to have companies and their directors understand that their personal integrity is critical if the company is to fulfill all of its responsibilities. And then have these companies come forward and tell the true situation about where their company stands before people are caught by surprise and wind up losing all of their personal monies.
Rafael, você encerra o bloco.
Vamos lá. Aproveitando as perguntas a propósito da colaboração premiada, a prática no Brasil, né, talvez o senhor tenha ouvido isso na imprensa, tem sido a prisão cautelar até que a pessoa colabore, né? Então, há questionamentos a respeito da validade dessas colaborações feitas, né, nesse contexto. À luz do sistema jurídico norte-americano, como o senhor vê isso, né? A colaboração de pessoas encarceradas?
Jailing people to extract confessions and to extract accusations about others is antithetical to the U.S. justice system. The goal is that no one should be arrested or jailed unless there is probable cause to believe that they may have been involved in a crime and that they get a speedy trial so that the possibility that they engaged in criminal conduct can be determined by a jury of one's peers. So preventative detention is not a viable approach in the U.S. People do get detained before they are charged, but they cannot be detained for a year or months on end, and there have to be very careful evidentiary hurdles that are met. But the goal is to come up with not confessions or accusations, but hard evidence that demonstrates that somebody else may have violated the law. Otherwise, you have convictions built on a house of cards, and the minute a mild wind comes by, it will blow the entire house down.
Teremos agora outro breve intervalo e voltaremos em seguida para o quarto e último bloco da entrevista com o consultor Harvey Pitt. Estamos de volta para o quarto e último bloco da entrevista com o consultor Harvey Pitt. Mr. Pitt, o senhor, que tem uma experiência razoável já nessa área, o senhor já viu, já soube de algum esquema de corrupção com as dimensões alcançadas pelo que aconteceu na Petrobras?
I have seen that, unfortunately, in the U.S.
Por exemplo?
Yes. Back in the early to mid-1970s, we learned that many U.S. companies were paying bribes to foreign governments to obtain or retain business. I, at that time, was general counsel of the SEC, the senior lawyer for the agency. The number of companies that were engaged in bribery was staggering, and it wasn't one company, it was many companies. And we handled this by coming up with a program to require all companies that engaged in this conduct publicly to admit to it and to declare that they would not do it anymore. And we had legislation adopted to make it a crime for any company to engage in similar conduct in the future. Years later, after I was out of the SEC and in private practice, there was a huge scandal involving Salomon Brothers, which had tried to corner the market in U.S. Treasury instruments. And I defended the general counsel of Salomon Brothers at that time. And the U.S. took action against Salomon for its misconduct. There have been cases in which companies have been grouped together. The goal in many of these cases is to stop the corruption, stop the misconduct immediately, and assure the public that they will know who did what, and to find those companies who may have been responsible according to their involvement and clean up the markets immediately. It requires a willingness to forego personal aggrandizement, no credit for picking up scalps and so on, but rather for cleaning up the marketplace, which is what the SEC's job is.
Perfeito. Lembrando que esse bloco é mais curto, Laura.
Mr. Pitt, eu queria só uma explicação mais detalhada a respeito das perguntas que eu fiz no último bloco. Então, eu vou fazer de outra forma. A que se deve o aumento de interesse do Departamento de Justiça nas pessoas físicas? Essa é uma. E a outra é, se o senhor não acha que a punição ideal para as pessoas físicas, para os executivos, no caso, é a prisão, a punição ideal para um crime seria pagamento de multa ou alguma coisa financeira?
Corporations are legal fictions. You cannot put a corporation in jail.
Okay.
Corporations cannot act except by the conduct of individuals at the corporation. So there is a view in the U.S. That corporations that do wrong should not get away with that, and they would have a financial penalty. They cannot, as we say, be put in jail, although they might lose the ability to do certain types of business as a result. And those individuals who are responsible should also be sanctioned, and for those individuals, often putting them in jail for some period of time is seen as the most effective tool. It depends in each case on the nature of the violation, the role of the individual, and the harm to the public.
E por que o anúncio foi feito só no passado?
Laura, eu preciso... Você tem ligado à pergunta que você fez?
Eu ainda não entendi.
Senão não completo a roda. Fala.
O senhor disse que sim, claro, as empresas são ficções e são jurídicas e são feitas, na verdade, no dia a dia das pessoas. Mas por que esse anúncio foi só ano passado? E não há 10 anos, quando as empresas já eram feitas por pessoas? Eu quero entender o timing.
Em seguida, Helen.
When the economy in the U.S. Crashed in 2007 to 2008, many people expected to see individuals go to jail. It proved impossible to bring cases against the individuals, and justice decided to re-emphasize that no company could get credit without helping to determine whether individuals engaged in misconduct.
Helen.
Aqui neste programa, um tempo atrás, o correspondente do Jornal Estado de São Paulo, em Genebra, o Jamil Chad, disse que se a gente está vendo hoje a corrupção de grandes corporações vindo à tona, a gente deve muito ao presidente Obama, que em 2008, com a crise, começou a pressionar paraísos fiscais para que eles abrissem dados de executivos e de grandes empresas para poder fazer, então, alguma repatriação de recursos. O senhor concorda com esta afirmação? E, se concorda, isso não deixa mais evidente de que, quando quer, o governo consegue mesmo combater as práticas ilegais?
I think the problem is more complicated. One of the advantages I have in answering questions like this is that I am not running for any office, so I can be completely truthful. In the U.S., as we are seeing right now, people who are running for office have a difficult time being truthful. My view is that if there is evidence and companies are withholding that evidence, there should be pressure brought to get that evidence. On the other hand, foreign secrecy laws do serve important, critical functions, and one cannot simply say there should be no application of a foreign secrecy law. The issue should be, what is the appropriate way to learn whether people in the U.S., for example, have engaged in crimes by hiding information overseas. That, I think, is an appropriate policy.
Rafael Valim.
Vamos lá. Há uma discussão muito atual, né, que no marco da vigente lei anticorrupção brasileira, sobre a extensão dos nossos chamados acordos de leniência, né? No Brasil, atualmente, esses acordos só alcançam as empresas, portanto, não têm efeitos, né, criminais e tampouco efeitos civis e administrativos para as pessoas físicas, né? Como funciona no direito norte-americano, né? Os chamados acordos aqui de responsabilidade mencionados pelo senhor, qual a extensão deles? Eles alcançam as pessoas físicas e também têm efeitos penais, efeitos criminais?
There are two parts to this question. First, when there is a corporate responsibility or leniency agreement, it should provide a solution to all possible avenues of potential legal issues facing the individuals or the companies. That is to say, not just criminal, but administrative and the like. So our agreements frequently will become global agreements in which all of the agencies of government will join together. As to individuals, a company that tries to settle with a corporate responsibility agreement is harmed if after it settles, the cases go on and on forever with individuals from the company being charged or tried. So there is some desire to try and get those individuals to be encompassed. The government in the U.S. is facing serious challenges now from the press and others if it makes arrangements with individuals, but often making arrangements with individuals is the only way to find out what really happened. And the best approach is to come up with a global resolution of a particular problem so that everyone knows what happened and all those who are responsible are now subject to an agreement.
Obrigado.
Márcio Klein.
O senhor tem alguma restrição sobre a participação de empresas de capital misto no mercado de capitais? Digo isso porque no Brasil o governo é o acionista majoritário de empresas como Petrobras, Eletrobras, Banco do Brasil, que são importantes para o mercado em si. Há alguma restrição para o bom funcionamento do mercado de capitais tendo empresas de capital misto?
In the U.S., until 2008, the rule was ironclad. The government could have no interest in any private company. In 2008 and 9, the Obama administration created arrangements, for example, with automobile manufacturers in which the government became shareholders. Part of the reason why those agreements are usually prohibited is because then the government has a conflict. If the government, for example, owns an interest in General Motors, but does not own an interest in Ford, General Motors may get more lenient treatment from the government than Ford will. And the result of this is that it is generally prohibited without special exceptions for the U.S. government to own shares in any private company.
Fernando Torres, você faz a última pergunta.
Ok. Mr. Pitt, algumas das empreiteiras que estão sendo acusadas na Lava Jato, elas não têm ações nos Estados Unidos, mas elas emitiram títulos de dívida naquele país e também algumas têm até subsidiárias lá. E essas empresas atuaram, segundo as investigações, na ponta ativa de corrupção, pagando propina para obter ou reter contratos com uma estatal aqui no Brasil. Essas empresas, elas estão sujeitas, sim, a serem processadas segundo a legislação americana?
They can be, yes. The mere fact that the parent company does not have outstanding equity stock does not necessarily mean that there aren't U.S. investor interests. Debt issuances will provide jurisdiction. If the subsidiary has issued warrants or American depository receipts or other provisions like that, they are fully subject to U.S. laws and can be sued in the U.S.
Infelizmente, o nosso tempo acabou. Eu agradeço a participação do Fernando Torres, do Márcio Croin, da Laura Diniz, da HELEN BRAUN e do Rafael Valim, também do nosso cartunista Paulo Caruso. Agradeço a você que nos acompanhou até agora e especialmente ao consultor Harvey Pitt. Muito obrigado por esta entrevista bastante esclarecedora. Os brasileiros ainda estão, eles não sabem direito, não sabiam antes do programa aqui, do que se tratava, compliance, como é que se faz com essas empresas envolvidas em irregularidades. Acho que o senhor contribuiu para que fiquem bem mais informados. Muito obrigado. Boa noite a todos e até segunda.